Court will note the appearance of Ms. Podolsky on behalf of plaintiff, Mr. Vanderhorst on behalf of defendant. The matter is before the court on the plaintiff's motion for temporary custody, parenting time support, use of our family wizard. I guess that last item, Ms. Podolsky, if you saw Mr. Vanderhorst's answer, they said they're not opposed to our family wizard. So being that there's no opposition, the court will grant that. You can proceed with the rest of your motion.
Thank you, Judge. As we stated in our motion, these children are ages 4 and 1. In fact, their youngest just turned 1 within the last 2 months or so. My client and the minor children have been residing here in Calhoun County in the state of Michigan since January of 2024. They moved up here from the state of Georgia. That is where the defendant continues to reside. Since that time coming here and moving to Michigan, the plaintiff, my client, has been the sole and primary caretaker of these minor children. The defendant has not had parenting time with them. He has not spent overnights with them. The children have not gone back down to Georgia to spend parenting time with them. Instead, for the last several months, what he has been intent on is texting and calling and harassing my client more about getting back together rather than co-parenting, being a part of these children's lives. She tries to send updates, text messages, pictures, video, tries to video chat, though that can be difficult with children of this age. But again, the defendant is more intent on attempting to reconcile and then berating and belittling my client when he's not hearing what he wants to hear. So we are very concerned that at this time, for him to have any sort of overnight parenting time with the minor children, they at this point do not know him, especially their 1-year-old, to order unsupervised overnight parenting time with these children would be a risk of harm because they don't know him, because of concerns of him stating, I want to terminate my parental rights. We don't know where his head is at. So we have very serious concerns about that. It, unfortunately, with their youngest would be akin of leaving the child with a babysitter overnight, somebody that the child doesn't know because he has not been there for the last 10 months. So we do understand that he wants to come to the state of Michigan at the end of this month. We have offered parenting time after school. The 4-year-old child is in school. We've offered parenting time after school to be supervised each day while the defendant is here in the state of Michigan, but we do not believe overnight parenting time is appropriate at this time, nor do we believe that unsupervised parenting time would be appropriate due to the significant length of time that he's been absent from their lives. So we're asking this court to order the sole physical and legal custody of the minor children to the plaintiff, that the defendant, any parenting time that is ordered, be supervised and here in the state of Michigan without overnights, and that this court order child support to be calculated pursuant to the Michigan child support formula.
Thank you. Mr. Vanderhorst?
Thank you, Your Honor. The parties do have 2 minor children, ages 4 and 1. The parties were residing in Georgia until the plaintiff mother left Georgia and moved up here with her parents in Michigan. The defendant father did not know the plaintiff's intentions was to leave basically Georgia and reside in Michigan with no intention of coming back and then subsequently file for divorce. Defendant is employed as an investigator in Savannah. Since plaintiff has moved to Michigan, he did come and see the children in April from the 9th through the 15th. The defendant father does have a strong relationship with the children, especially the 4-year-old. 4-year-old spent substantial time in Georgia while the parties were residing together. The 4-year-old spent the majority of the child's life in Georgia. Defendant father is a very loving father, and he does care for the minor children. He was inquiring of the plaintiff because he was kind of confused with the situation on why she left and why she's not returning, and also why she shut down all access to the minor children. Defendant really misses his children. He really wants to see his children. So he is proposing he would like to come to Michigan sometime after October 26th. If the court does grant that request for a period of 2 weeks, he would like to spend unsupervised parenting time with the minor children in a hotel if possible. I could get with Attorney Podolsky if the court would order the 2 weeks for October, the specific dates that he would be coming. Any additional parenting time, he's requesting that that be in the state of Georgia. He would like holiday time, especially over Thanksgiving. possibly over Christmas time, until a final parenting time and custody arrangement can either be settled on or if we have to go to trial on that issue. So during the pendency of this action, the defendant is requesting that the court order that the parties be awarded joint physical, joint legal custody. He have unsupervised parenting time in 2 weeks in October, late October and in November, and then holiday time in the state of Georgia. Thank you, Your Honor.
Thank you. Ms. Podolsky, anything else?
Just briefly, Your Honor, I think it's disingenuous to say that he did not know that my client wasn't moving back to the state of Georgia. He was very well aware. These parties have a significant text message history where she has repeatedly told him the relationship was over. And then she didn't file for divorce until she met that 6-month requirement. In fact, didn't file until she'd been here 8 months in August of 2024. At no time during that period did the defendant attempt to file a case in the state of Georgia, attempt to get a parenting time order, a parenting time schedule, engage in any sort of reunification counseling, or in any sort of parenting time in general with the minor children. So he very much knew she was not coming back to the state of Georgia. She's employed here. She has housing here. He knew that was not the case. So at this time, again, we're requesting that any parenting time that is ordered occur here in the state of Michigan and that it be supervised.
Okay, thank you. Well, in this case, it's clear that she has been here since January of 2024, that the defendant has not had really any significant contact with the children since that time. So to preserve the established custodial environment, the court will grant to the plaintiff the legal and physical custody of the children. Court will order support consistent with the child support formula and the guidelines. In this matter, as I stated previously, the parties will communicate through our family wizard. In this case, their court is going to grant parenting time to the defendant if he wishes to come up for those 2 weeks. The court will grant him parenting time during the first week that he's here, from after school until 8 p.m. with both children. Then the second week, the court would grant that second week continually with the defendant during the time that he is in Michigan. After that, the parties will alternate holidays in this particular matter, and the court will grant to the defendant the Thanksgiving holiday, and that can be extended in this matter, and he can exercise that. If he wishes to exercise it in Michigan, he can. If he wishes to exercise it in Georgia, he can. It's up to him, and he'll have to make arrangements to accomplish the exchange of the children. The court would order that the parties would meet at a halfway point. Leave it up to the parties and the attorneys to figure out where that halfway point is, and that would continue. Otherwise, it's going to be really hard to accomplish any other parenting time other than on the holidays in this matter until we get to summer. So I guess I'll leave it for a period of time for the parties to try to figure out what they'll do at the other times. I will give him the spring break in 2025. And then obviously after that, we should be able to get back to resolve issue of summer before that would come up. So Ms. Podolsky, will leave it up to you to prepare that order and submit it under a 7-day.
Okay, I just want to confirm that second week he's here in Michigan, he would have both children with him, and that would include overnights?
Yes.
And would the party's oldest still be ordered to attend school during that time? So defendant would need to get the minor child to and from school?
Well, yeah, he'd have to take the child to school and make arrangements for that.
Okay, thank you. I just want to make sure.
Okay. Okay, thank you. You're free to go. Have a good day.
Thank you.
Court will note the appearance of Ms. Podolsky on behalf of defendant. This matter is before the court on the defendant's motion for parenting time and other relief. Ms. Podolsky.
Thank you. It was really more regarding some issues with parenting time. I will start with the parenting time exchanges. There was a trial in this matter a few months ago, and the parties were ordered to exchange parenting time at a gas station area in Marshall. Unfortunately, the plaintiff father is consistently late to parenting time exchanges. The very specific time for the parenting time exchange was set due to my client's employment and the time that she does have to get to work. So when he's late and he's not communicating with her, she's late to work. She's having to scramble to find her parents to meet her there to then meet him. So we're asking this court to order that the plaintiff communicate when he's going to be late, that if he is 15 minutes or more late and has not communicated with her, that the visit is canceled. And if he has communicated with her and still has not arrived 30 minutes after the scheduled meeting time, that the visit be canceled. Second, as of late, visits have been occurring in the home of a woman in Albion. Her name is identified in our motion. At that home, the minor child doesn't have a bedroom. He doesn't have a bed. He doesn't have a bedtime. There's often no food in the home. We've detailed a contact that the minor child had with my client during a recent parenting time where he detailed his father and this woman fighting. He had to go out to a vehicle just to escape the fighting, and there was, again, no food in the home. Unfortunately, the fighting is a consistent issue in that home. And again, we've outlined some of the criminal history that this woman has. Since the filing of this motion, the plaintiff has indicated that he is now married to her. He did send my client what he purported to be a marriage certificate. However, it was not signed by anybody who was authorized to perform a marriage, nor was it witnessed. So we believe this was just an application for a marriage license and not an actual marriage certificate. Lastly, this court has previously ordered the use of Our Family Wizard. And finally, the plaintiff is using it. However, he's now using it as a weapon, telling the minor child, I can't communicate with you unless it's on Our Family Wizard. The order is very clear. That is for the parties to use and communicate with each other. That is not for the children. It is not expected that a child communicate with a parent through Our Family Wizard. Yet the plaintiff continues to contact the minor child and state, I can't talk to you. I have to block your number because I can only talk to you in Our Family Wizard. Lastly, the court did order counseling between plaintiff and the minor child. To date, this was ordered November 15th of 2023. It's been almost a year now. The plaintiff has not begun that counseling. My client has had an intake appointment with Margaret Hunter, who will handle this type of counseling completely on Zoom. So despite the fact that plaintiff does not live in Calhoun County, it is not a barrier to him participating in counseling. This was testified to at our last referee hearing in June, and still the plaintiff is yet to engage in any of this counseling. So we're asking the court to grant the relief requested as it relates to parenting time exchanges, the location of parenting time, to begin counseling with the minor child and Margaret Hunter, and to unblock the minor child's phone number and understand that Our Family Wizard is for the parties to use, not the plaintiff and the minor child. Thank you.
Okay, thank you. Mr. Irons, go ahead.
Your Honor, on Our Family Wizard, I would just like to state, when you log into there and it goes to subject, and it also states like, what are you on there for? It says Abigail Kidder, and it says DeJuan Irons. So under my impression, that is what we're supposed to use to communicate. Also, I was indicated that by Mrs. Kidder that I need to communicate on there. So my son, our child, DeJuan, he calls me a lot, like regularly on the phone. But I told him that I have to communicate with him on Our Family Wizard because that's what I was told, and that's where his name is indicated. So if he's not supposed to be on Our Family Wizard communicating with his father, why is his name listed as one of the parties to communicate with on Our Family Wizard? So maybe there's some discrepancy or some misunderstanding, but as far as what Our Family Wizard states, his name is on there. So I figured that's where I'm supposed to communicate with him and not on the phone. So once I found out, hey, oh, no, he still calls my phone, so I unblocked his number. But I'm confused with that part, Your Honor.
Okay, well, let me clear up the confusion then. Our Family Wizard communication is just for the parties in this matter. There's no prohibition against contacting your son on his phone or him contacting you in this matter. So there's no need to have him blocked or anything of that nature. So you can continue to communicate with him vis-a-vis phone or any other method necessary. What the court can do on the relates to the exchanges is provide that again, when the exchanges occur, that the plaintiff would have to wait the 30 minutes after the exchange time. And if the defendant does not appear within 30 minutes, then he forfeits his parenting time, whatever that parenting time would be. If it's a weekend or a week or whatever, he forfeits that available parenting time. If he is in fact at the exchange point more than 30 minutes after he's supposed to drop the child off, then he forfeits his next available parenting time. So whatever the next available parenting time was, if he's there past the 30 minutes, when it's required to drop the child off, then he forfeits his next parenting time. The court would order that the plaintiff would commence counseling with Margaret Hunter, that he would have an appointment set up, and he would set that up within the next 30 days. And I think that addresses all of your issues, Ms. Podolsky. Is that correct?
Just the last item being the location of parenting time. It's our understanding Mr. Irons does live in Lansing. When the minor child was having parenting time there, he at least had a bedroom and a bed, and he was fed. That's not happening at this home in Albion. So we're asking that parenting time not occur in this woman's home because of all the reasons stated.
I'm not going to order that at the current time. If in fact it is not an appropriate environment for the child, then you can always contact Family Children's Services and or Child Protective Services, I'm sorry, and get them involved to see if it is not appropriate. Mr. Irons, I think you were trying to say something.
Yeah, I was just trying to address the issue concerning the parenting time with Dewan and Albion. I would agree, meaning I am agreeing to the fact that he does not need to spend his weekends there. He is, to spend his weekends with me at my home.
Okay. Well, we can include that in the order if that's agreeable. And that is at the home in Lansing, sir?
Yes, Your Honor.
Okay. You can include that then, Ms. Podolsky.
Okay, thank you.
And
For the weekends, he said.
Mhm.
Right, correct. And also, Your Honor, I would like to address the issue of pickup and drop off.
Well, I've already decided that, so we don't need to address it. I'm sorry. There's a 30-minute window and that's it. So,
but I don't get out of work till 5 o'clock. How can I make it from 5 o'clock to Marshall? It's a 45 to 50-minute, maybe an hour drive, depending on the highways lanes closing down. Like, I get out of work at 5. He expects me to be there at 5:15.
Okay.
I have to.
Is there a problem with going later, Ms. Podolsky, like having the exchange occur at 6:30?
The only issue is my client is at work by that time, so she would have to make arrangements with a third party, like the minor child's grandparents, to then be there every other week to make that exchange.
Well, why don't we try that and see what we'll do, sir? We're going to move it to 6:30 p.m. and see how that works. If it doesn't, then we'll have to work on something else.
It will work. I will make it work, Your Honor.
Okay.
And will the Sunday pickup continue to be 4:30 as ordered?
You don't have any problem with doing that at 4:30 on Sunday, do you, sir?
No, that's fine, Your Honor.
Okay. Include all that in the order, Ms. Podolsky, and submit under 7-day.
I will, thank you.
Okay, thank you. You're free to go. Have a good day.
You as well.
Two.
Court will note the appearance of Ms. Capture on behalf of plaintiff, Ms. Town on behalf of defendant. This matter is before the court on the defendant's objection to the referee recommended order dismissing the motion and motion to set aside recommendation. Ms. Town.
Good morning, Your Honor. Can you hear me okay?
Yes.
Thank you, Your Honor. Yes, we are filing an objection regarding the motion, or the order that dismiss the motion based on no change in circumstance. So this judgment of child support was entered back in January. The party signed off on this in December. At the time, it is true my client did not have a job and income was imputed to him at that time. But since that time, 10 months later, well, actually 3 months later, he obtained new employment. He's earning somewhat less than what he made at the last job for an hourly rate, but he's not getting the kind of overtime that he was making from his prior job. So there's clearly a change in circumstance in this case because he is employed now. He is earning an income. He is paying his support, the support of which happens to be more than 50% of his disposable income being deducted from his paycheck, which, as this court knows, is not allowed by state and federal law. It's consistently causing him to become in arrears every single month because the support is higher than what his income is every single month, and he's still making an effort to attempt to pay it. The court, or the front of the court in this case, just said that they're dismissing it based on no change in circumstance. The circumstances have been over 10 months. He's been trying to pay his support and catch up after obtaining this new employment in March. The support has to be modified just on that change in circumstance alone, but we are requesting that de novo hearing. I understand that attorney capture is attempting to argue an imputation, and I appreciate that argument. In this case, however, my client's already working 40 hours a week. He is not able to earn the prior income that the support was based on. He can show that in a de novo hearing and show what the support should be based on with that respect. I'm going to also refer to imputation of income, and we've got the Michigan Child Support Formula, section 2.01G. So the case cited by attorney capture is the roll-off case from 1987. The child support formula has been modified significantly since that time. It clearly says even if there's a crime committed, that's not a basis to impute income. I understand my client, he did not voluntarily quit his job. He was terminated. I understand it was based on his misconduct, but he's attempting to earn an income, pay his support timely, but in a manner that's consistent with Michigan law. So we are asking that the court let his motion go forward on the modification of support and grant him the de novo hearing, which he's allowed by law.
Okay. Well, I looked at Ms. Capture's response, her answer. She states in paragraph 13 and paragraph 15 that in fact your client was terminated prior to the last order, and that was a consent order. He consented to the imputation of income. Is that right?
My understanding is that it was a consent order, that at the time he was contesting the termination of his employment, that even if it was continued to be terminated, he would be able to find employment somewhat at that level. He has not been able to do so. I might myself agree with attorney capture's argument if my client had filed a motion to modify, say in March. But we are 10 months later now. He filed this motion in August. He's climbing. This is an uphill battle. He's not going to can't be able to go above and beyond the support arrearage that's taking more than 60% of his income out, where they can't do it. They can't withhold it. So he's not able to pay that level of support anyway. And he's already working more than 40 hours a week, quite frankly, on a number of these weeks, with the income level that we alleged in our motion, that would be even more than his 40 hours a week as well.
Okay. Ms. Capture, your response.
Thank you, Your Honor. Like you just stated, this was a consent order. Mr. Hance did realize that he could have imputed or agreed to an imputation at a lower level. However, he did not. Furthermore, again, the change of circumstances may have occurred back in March. However, he didn't even let FOC know until I believe July, when he finally started making child support payments. He had significant arrearages until August. And I believe his most recent arrearage didn't clear until we had worked out a consent agreement between ourselves and Mr. Hance to allow for the funds that were to be used in the equitable division of the divorce. Those funds were released to pay back due child support. So again, as I stated in my answer, Mr. Hance went and bought a brand new vehicle. He's been making regular payments, assumedly, on that vehicle. To say that he is unable to make these payments is not true, because he also doesn't have his own residence. He lives with his father. He doesn't have any costs associated with that. The fact of the matter is, Your Honor, is we don't have a change of circumstances here. He agreed to the imputation, and he was fired prior to that imputation occurring. He was also fired due to his willful actions. Yes, the roll-off case is an older case, but that does not change the fact that it should be construed as a voluntary termination. Thank you.
Okay, thank you. Ms. Town, anything else?
Again, Your Honor, the court would have to go through very specific factors to be consistent with the Michigan Child Support Formula to impute this income to him. I understand the issue is change in circumstance. I assume that if Mr. Hance had obtained a job where he was making significantly more than the $75,000 that was imputed to him, that attorney captured his client would be asking the court for a change in circumstance. So I'm not sure how it could be perceived that there's no change in circumstance when there has been new full-time employment gained.
Okay. Well, in this matter, clearly, and it's acknowledged today, as well as the pleadings, that the defendant had entered into a consent judgment, a consent order in this matter, again, acknowledging that he would pay the support based upon the imputed old income. So the court, basically, the parties have an agreement as to that particular point, and you can't say, okay, well, 3 months later would be the appropriate time to change that, or 10 months later, whatever it might be. Obviously, he knew at the time that the order was entered into that he wasn't making that kind of money. He did not take advantage of, again, a recognition of that, but in fact agreed to be imputed to that. The court would, however, recognize that Mr. Hance, as stated by Ms. Towns, is not getting the overtime, so he does have a reduction there, which would not be something that you would take into consideration. So what the court will do is the court will continue the imputation at the amount of the other order at the hourly rate from the other one, less the overtime. So again, if he's not getting the overtime, the court would not impute that amount, but I would continue the imputation at his hourly rate from the prior employment. So Ms. Town, I'll let you and Ms. Capture work on figuring that out, but his hourly rate would continue imputation, but not the overtime that he had from the prior employer. And then you can recalculate support based on that.
Okay. Just to clarify your ruling, Your Honor, I know this court's busy. Your ruling today is to recalculate based on his prior hourly rate at 40 hours a week.
Yes.
And then this is retroactive to the date he filed his motion.
Yes, to the date, well, date of notice of the motion. So you'd probably be, I was going to say 3 days, but the mail is probably about 5 days late. So I have 5 days after your filing.
Thank you, Your Honor.
Okay. Thank you. You're free to go. Have a good day.
You have a good day as well.
Thank you, Judge.
Dorothy? Can you hear me, Dorothy? Dorothy? Please connect to audio, check your volume settings. Can you hear me? Can you hear me, Dorothy? We cannot hear you.
Hello, I can't use my earbud. Obviously, you guys
Okay,
aren't hearing me.
I can hear you now, so we're good. Colleen,
Yes, I know, but I'm trying to make it so only I heard the court and not everybody in the house.
Okay. Calling case.
My earbud's not working.
6 a.m.
Court will note the appearance of Ms. Henderson on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Henderson.
Good morning, Your Honor. This case is somewhat unusual. The parties have been separated for over 5 years and actually have a DS case that is now closed. However, the divorce was actually never finalized, so we were directed by the court administrator to file a new divorce case and a motion in that case. The parties share 2 minor children. One of them is about to turn 18 in the beginning of 2025, and they share a 9-year-old daughter, Trinity. And pursuant to the case in the support matter between the parties 2019-3226 DS, my client has sole legal, sole physical custody of the minor son of the parties, and then the defendant in this matter has sole legal, sole physical custody of the party's minor daughter. Subsequent to the filing of the initial order in that matter, there was a order establishing parenting time that entered in 2023. And since that time, specifically in October 2024, right before we filed for divorce, there's an ongoing CPS case involving the defendant in this matter, who was substantiated for physical neglect, medical neglect of the child, as well as deplorable living conditions. And the minor child of the parties, Trinity, was safety plan outside of the mother's home. And due to mother having sole legal, sole physical custody at that time, mother insisted that she be placed with third parties rather than her father, who has appropriate living conditions at this time and has no allegations against him. Since the filing of our case, Your Honor, as of the end of last week, Families First is in defendant's home and they're working on reintegration of the child with the mother and also providing some services for the mother. The mother still does not have transportation. The child still has lice. She is in need of immediate medical and dental attention due to severe tooth decay. And we're asking for Trinity to be placed with the father pending the resolution of this case. We're asking for continuation of sole legal, sole physical custody for Mr. Lien for the older child of the parties, their son. We're also asking for him to be granted sole legal, sole physical custody of the daughter pending this matter. We understand that the court may want to have an evidentiary hearing, and we would be prepared to do that. But we contend that due to the recent development regarding the defendant's home, as well as her romantic relationship with who Mr. Lien believes to be a registered sex offender. Further, Ms. Lien has an adult son who also has some registered sex offender, according to my client, or some deviant sexual behaviors that he is aware of. All of that in totality would constitute proper cause for the court to revisit custody and parenting time for Trinity. We're asking for that to be considered at this time, Your Honor, for Trinity to be placed with her father and for the parenting time to be granted for the parties in accordance with the safety plan and the ongoing CPS case recommendations. Further, we are asking for any parenting time exchanges to occur at Battle Creek Police Station due to a highly contentious relationship between the parties. Now, I understand currently Ms. Lien does not have any transportation, and until she does have transportation, my client is willing to pick up at her home. But going forward, once she obtains transportation, we would like for the exchanges to be moved to the police station of the parties, of Battle Creek, I'm sorry. Further, we would ask for the child support to be ordered in accordance with the formula. My client is employed full-time at Walmart, was stated his gross biweekly income. To my client's knowledge and belief, defendant is not gainfully employed and has carnival work when it's available. And we would ask for her to be imputed at $15 an hour, 40 hours a week. The child currently has a medical insurance provided by my client. She also has secondary Medicaid insurance. There is a dire need for her to see a dentist as soon as possible. Due to no transportation, we are uncertain how Trinity would be getting to school because it's our understanding she is not attending school in the district in which defendant resides. My client would be able to take the child to school, make sure she's attending school. And for all of those reasons, we're requesting temporary legal and physical custody to be awarded to my client to continue sole legal, sole physical custody of the older child with Mr. Lien, to order parenting time in accordance with the CPS ongoing guidelines, and order child support in accordance with the formula, Your Honor. Thank you.
Thank you. Ms. Lane, what's your response?
Well, my response is a lot, Your Honor. I have Trinity actually in my care. Trinity was given back to me. Actually, I could have got her back Monday, but I waited until her dentist appointment that she had scheduled Tuesday to take care of her dental problems. And they're going to be running a test actually for periodontal disease that runs very highly in my mother's side. I just recently found out from my aunt that's involved like at least 7 of my family members on my mother's side who are still living, who had periodontal disease, which causes teeth decay, even with people who brush and floss and take good care of their teeth. She goes to the dentist yearly to get her teeth cleaned and to get her fillings taken care of if she needs any. And she has been in my care the whole time since I have left Tony. Trevor wanted to go with his dad, and that was fine. But Trinity has been wanting to be with me. Our visitation, I had set for open visitation back in February 2020, and he went back to get things changed because he wanted to cut her hair, and I wouldn't allow it because it was above her shoulder, and she wanted it to be longer. And at that time, they were going to issue him Wednesday and Friday 4 hours visitation, and he told them he can only do 1 day a week because of their aggressive dog at their home. He says he now lives at the girlfriend's house. I do not know because the address he gave me is a false address. Because I asked if she is going to the other party's house, which I am not against her going to her house. I am very, I like to know where my kids go, even when they go to a friend's home, I like to know the address. I like to know where they're at in case of an emergency. And, with behaviors he has pointed to me, it makes me concerned. So I just like to know the address because he's threatened to kidnap her and take her to that address prior this year. And he has kidnapped her 1 day last year. I am making an appointment for her to get her, she has to get a root canal, which is why I'm getting her tested for the periodontal disease, because there are 0 reasons for her to have to be getting this root canal. Because at the last dentist appointment, she had a small cavity on this tooth, and it did nothing to obtain a root canal now. So my aunt let me know about this disease, so I'm getting hold of Dental Dream, and I'm going to have her tested for that. She gets to her eye doctor yearly. CPS has ordered a bed for her because I'm in the process of looking for a home. And as far as income, I'm on long-term disability because I had my posterior tendon surgery done twice on my left foot. And because I cannot be on my feet for 8 hours straight, my job at Tentacle said that I'm no longer employed there, but they put me to long-term disability. And once I can be on my feet for at least 8 hours, I can get my job back with them. So I've been doing physical therapy, and so I can strengthen my foot, and I have to wear an ankle brace to help support it. I'm working on getting my food stamps back. They had my mail was being resended back to them from my old address before I came to my mom's address, which my mom's house is significantly, oh my goodness, so much better. We have hot and cold water running to the showers. We can take showers now. The sink and tub works upstairs. The toilet works upstairs. The house is fully clean. CPS was totally surprised in there. So she has her own bedroom. Like I said, she's been in my care this whole time. And this whole thing started because he doesn't want to pay me child support. He's told multiple people. He's even told me for the last 6 years of our marriage that he would not pay me child support at all. I would tell you the mantra, but I don't think you want to hear it. I hear it every day in my head. Overnights are allowed, and I talked to a lawyer, and she has me having some stuff that she wants to make sure I bring up to your guys' attention. So I'm just making sure that I hit everything that she had spoken to me about, because I was not served in enough time to actually get to me and a lawyer. So I was able, as far as, because it was a domestic marriage for me and the children, physical, mental, and verbal abuse. I had to go through Safe Place. A legal aid told me to go through Safe Place legal services to be screened, to be sent back to legal aid. And they finally went through that process, and that's how I finally got to legal aid.
Okay, anything else, ma'am?
Yes, Tony himself is actually a CFC. It was expunged, but there's still sites that you can find it on, because my cousin Laura found it. I've never let my boyfriend watch Trinity, and I don't let Randy watch Trinity because Randy is autistic.
Ma'am, just in
So
that regard, are those individuals, are Mr. Wright and Mr. Brett, are they registered on the sex offender registration?
Randy is not. Randy was found criminally and mentally incompetent, so Randy was not charged of nothing. So Randy does not have a record, Your Honor.
Okay.
My boyfriend, it was a teenage thing, Your Honor. And what my understanding is that he was charged of his girlfriend who he was having consensual sex with, but she was caught having sex, and to cover herself, she yelled rape. And as far as the other girl, I understand that she was the younger sister who had a crush on him, and he was not giving her any, time or day because of her age. And she did the same thing her sister did. And so that's how I was understanding that obtained. It was not a minor child, teenager, unlike her father. So for his safety, actually, I don't leave Trinity with him. Trinity and him have a good bond. But no, just because I don't want Tony to ever if Tony ever says he's gonna accuse anything, if Cody's never left alone with her, there's no reason anything can ever be said.
Okay, well.
And he never punishes her. He doesn't physically punish her at all. He's never physically punished her. And that, again, is on his safety side, because I don't want no accusation to get put towards him. So I am the only one that disciplines her, and my mother babysits, my daughter, my 21-year-old daughter babysits, or my Aunt Rosie has babysitted. I have other people in the family that I have babysitting her than him. And that's not because I don't trust him, Your Honor. It's because it's more his safety, so that people can't accuse anything towards him, if you understand what I mean.
Okay. Well, in this case, the court is not going to change custody without an evidentiary hearing. The case law is very clear that the court can't do that. So we'll have to schedule an evidentiary hearing. There is sufficient allegations to meet the VARCA threshold for an evidentiary hearing. The court will likewise note from what Ms. Lien has stated that she's on disability. So at this point, the court can calculate, we will at some point in the future, calculate the support based upon her disability. The exchanges can continue to occur at her home as she does not have transportation. And then at times she does have transportation, they'll handle that at the Battle Creek Police Department. The court is, however, going to order in this matter that neither Cody Wright nor Randy Brett will have any contact with the minor child when the child is in the defendant's custody or care. So, ma'am, what that means is they cannot have contact with her. You said you're not leaving them alone. That's not what it means. It means they can't be around her, etc. When the child is in your care. If the child is if the child is with the plaintiff, let's say a weekend, you can have all the contact you want with those individuals, but they cannot have any contact. They can't be in the home. They can't have contact with her when she is in your care.
I told him that. I don't understand why, Your Honor,
Because I just said so. Why that, ma'am? Obviously,
Well,
they're on, at least the boyfriend's on the sex offender list, and the child is not, court is not going to have the child in contact with them at that time.
I understand. I have a comprehension problem. Sorry, Your Honor. I was just trying to understand exactly why, because you said something about Randy, and Randy has been expunged. He does not have a charge or nothing against him.
Well, it may be, and you said that was a result of him not being,
He has autism due to.
he did not have the
extreme
capacity,
abuse.
but notwithstanding that, the court's going to order that he not be around the child.
Yes, sir.
Okay, that'll be the order. Ms. Henderson, you can prepare that, and then we'll be in touch with you about setting up a time to have a hearing.
Thank you, Your Honor. And would the hearing be with you, Your Honor, or with the referee?
With me.
Okay, thank you very much.
Okay, thank you.
Have a
Have
good
a good
day.
day.
24 at 9:54 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the front of the court's motion to modify a complaint to include the child in this matter. Mr. Magnuson.
Thank you, Your Honor. This is a case that was brought pursuant to the Child Custody Act. Our motion, I believe, is pretty self-explanatory. I think the laws of the state of Michigan and judicial economy require that both children be dealt with in this case. They're both the legal children of these parties and should be dealt with together. The reason we got involved was that we had received a referral for both children from the Office of Child Support. So we found this case, and I'm simply asking that the parties be required to include both children and modify their complaint to reflect that.
Okay, thank you. Ms. Stout, is there anything that you wish to state in this matter? And you're muted.
Please unmute.
Sorry, Your Honor. No, I'm okay with adding my son to the case. I know that he's legally his father. Just that we are trying to get him off his birth certificate because he is not biologically his father. But that's really it.
Okay. Well, the court will, in this matter, allow you to modify the complaint to add Levi in this particular matter. We can deal with it. Obviously, Mr. Magnuson, you might want to consider what Ms. Stout has stated in this matter, that again, that this case, that the plaintiff is not biological. I guess we'll might have to deal with that in the future.
Good. I agree, Your Honor. I think
Okay.
and that can be taken care of in the context of this case down the road.
Okay, go ahead and submit your order under 7-day.
I'll prepare such an order, Your Honor. Thank you.
Okay, thank you. Have a good day.
You do. Thank you.
24 at 9:57 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Mr. Robinson on behalf of the defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support with exclusive use, and the plaintiff's motion for a temporary restraining order. Go ahead, Ms. McNiff.
Thank you, Your Honor. Mr. Robinson and I had an opportunity to talk about this matter last week, and I believe that we have agreed that there should be a mutual restraining order, and I believe we've also agreed to grant each party exclusive use of their respective homes. We didn't talk about how payments would be made on those respective homes, but I would suggest that each party take care of any expenses associated with their respective home, property taxes, insurance, utilities, all those such things.
Okay.
The one issue that we don't have an agreement on is the temporary custody of the party's minor child, who is 3. These parties separated in late August. Since then, Dad has not even attempted to see the child, hasn't called Mom and asked for any parenting time with the child, hasn't come by the house. Dad still has a truck that's located at Mom's house, and it's available for him to get. She's tried to get that message to him. He hasn't gotten that truck. But we've alleged quite a few things in our motion regarding Dad's substance abuse issues, his alcoholism, his use of narcotic drugs, the fact that he was fired from a previous position for use of opiates. He has not been assisting her in any way with support of the child since they separated. She's paying $130 per week for childcare. Dad has not offered, nor has he paid the childcare provider. Dad knows where the childcare provider is. He hasn't attempted to contact the childcare provider to see the child either. We believe that it would be, and further, Dad, about a week after separation, moved a married woman, into his house along with her 5 children. He also resides with his 15-year-old. So there are 6 children in the house. We don't believe that it's an appropriate environment for the party's 3-year-old to see Dad already with another woman who also is married. And we're concerned about the fact that there are 6 children now residing in this house and Dad's ability to take care of the 3-year-old given that situation. We suggest an appropriate way for Dad to have parenting time would be to see the child at Family and Children's Services. And down the road, if Dad can get a substance abuse assessment, if he can test clean, if he is working, if all of those things are in place, then we could look at potentially expanding parenting time. But at this point, with all of those people in the home, we and Dad's consistent misuse of substances, we don't feel that it's appropriate for him to have that child on his own.
Okay, thank you. Mr. Robinson.
Well, Your Honor, my client denies the allegations of alcohol or drug abuse. In fact, he recently, he is employed, has been for quite some time. He underwent a drug and alcohol test at work, no alcohol present, and the only drugs in his system was the Norco prescribed to him by his physician. It's also monitored by the physician. He denies that, he buys his drugs on the street or that he uses his daughter Adderall. I would point out to the court that he has been awarded full custody of his daughter from a previous relationship and has had her in his custody for the last 12 years. I would also point out to the court that despite these so-called shortcomings, for the first year of this child's life, his father was a stay-at-home dad and took care of him at the plaintiff's suggestion because she earns more money than he did. He, of course, denies much of the other allegations. I'm looking at his phone log right now, and it shows attempts made by him to contact the plaintiff to see his son since they've separated, and she hasn't bothered to respond to any of them. She has told him to stay off the property. She's put up a fence across the driveway, a gate and fence across the driveway so he can't get on the property. He has talked to the daycare lady about how his son is doing. And we do have, while we do have no objection to the mutual restraining order and to the orders about exclusive use of the homes, he does believe that the temporary custody, the one that is most appropriate for this child, is shared custody, week on, week off. He's, when he was the stay-at-home dad, he was taking care of 4 kids, not just the one that he has with the plaintiff, but his daughter from his previous relationship and her 2 children from her previous relationship. When she was homesick with the flu, he took off work and took care of her. When she was homesick with COVID, he took off work and stayed home and took care of her. All of which was acceptable to her despite all of these claimed shortcomings of alcohol abuse and drug abuse. The court saw fit to award him custody of his oldest kid. I don't see why this court shouldn't see fit to award him shared custody of his youngest child.
Okay, thank you. Ms. McNiff, anything else?
Your Honor, we don't know anything about the allegation that Mr. Terry is employed. We would like to know what his hours are, whether or not his hours would be appropriate.
He's employed at Brembro through that temporary service like he's always been, or he has been for a long time. By the way, and he was not fired from his job in Union City. He quit that job. Yes.
We disagree with all of that, Your Honor. The other issue I would just like to bring out is that from my client's perspective, Mr. Terry did not take care of the child primarily, that he assigned most of the child care to the older children. He has a 15-year-old daughter. My client has older children, and that most of the housework and the care of that younger child fell to the older children and not on Mr. Terry. Ms. Terry took the child and put the child in childcare because she didn't feel that dad's care of the child was appropriate whatsoever. And we've detailed that in our motion.
Okay. Well, in this particular case, the court notes that the parties do have agreement on some of the issues that concerns the mutual preliminary injunction. The court will grant that, or will grant each of the parties the respective homes that they're using. So plaintiff would have exclusive use of the Burlington home, defendant would have exclusive use of the Albion home. The parties would be each responsible for the costs associated with the homes, meaning mortgage, taxes, insurance, utilities, maintenance, upkeep on the homes. In this matter, the court will note that the child has been in the care of the plaintiff since the separation in August. So the court will continue that and provide the plaintiff with the temporary custody of the minor child. Court will grant to the defendant standard parenting time. In this particular case, the court will order support consistent with the income of the parties, that the parties would exchange income information, paycheck stubs, whatever, showing their year-to-date income within 7 days of today's date. And the court would order that the parties would not consume alcohol or unprescribed drugs while the child is in their respective cares. So with that, Ms. McNiff, I'll ask that you would prepare that order and submit under 7 days.
I will, Your Honor. Thank you.
Okay, thank you all. You're free to go. Have a good day.
Thank you, Your Honor. Whoops, Your Honor.
Yeah.
Were you going to refer this to the front of the court for a hearing on?
No, I will do that.
Okay.
Court will note the appearance of Mr. Vanderhorst on behalf of plaintiff. This matter is before the court on the plaintiff's notice for entry of final order regarding parenting time. Mr. Vanderhorst.
Thank you, Your Honor. The plaintiff filed a motion regarding parenting time for 2 of the parents, Ryan Rankin and Simon Olmeda, both of the defendants. It was set for various evidentiary hearings. We came up with temporary agreements through the evidentiary hearings to see if those would work out. And ultimately, we did agree upon a settlement proposal. The defendant, Simon Olmeda, we've had no contact with him, can't get in touch with him or his lawyer. We've had no response. So the plaintiffs would like to preserve their motion, and pursuant to the both temporary agreements, that's what's referenced in our final order regarding parenting time. So the plaintiffs are asking the court to sign this order to preserve their motion and to have some of the terms contained in this final order carry over. And so we're just asking the court to sign this order. Thank you, Your Honor.
Okay, thank you. Mr. Rankin, yeah, no?
Mr. Rankin is not present.
Oh, Rankins are not present, okay.
We only have Attorney Vanderhorst, which is Diane Bridges and Savannah Bridges.
So, okay, Miss Bridges, do you have any opposition to the entry of this final order?
They're
No.
just-
No, we
Okay.
agree, we agree with the final order.
Okay. Okay, well, there being no opposition to this, the court will enter the order as submitted by Mr. Vanderhorst, and that will conclude your case. Best of luck. You're free to.
You said we are going on the record that he didn't show?
We're going on the record for the hearing, for your motion.
Okay, awesome.
Yep, hold on just a second. We're live on YouTube, so.
Okay.
Good morning, Ms. Lane. The court will note that this matter is before the court on the plaintiff's motion to determine the child is born out of wedlock in this particular case. Ms. Lane, when you came on briefly before, you had stated that you had not talked to the defendant in years. When was the last time you had any physical contact with the defendant?
I'm not sure the exact month, but it was winter of 2017.
Okay, so based upon that, the defendant could not possibly be the biological parent.
No.
Okay. What we're going to do is I'll tell you, we don't take testimony on Mondays. We do that on Wednesday. So we're going to have to set this up for a Wednesday hearing at 1:30. And what we'll do is that way we have to send notice out to Mr. Lane as well, so he can appear if he wishes to. If you want to, I know the alleged father is is it Lafarge?
LaForge, yeah.
Forge. If you have relationship with him and you want to have him in on that Wednesday, we can take testimony from him as well to establish him as the father.
Okay, that's perfect.
Okay, so we'll be in touch with you and set up a Wednesday. It won't be obviously this Wednesday because we have to give sufficient notice. So we'll see if we can get it in a week from Wednesday or maybe 2 weeks from Wednesday based upon your schedule, et cetera.
Okay, Your Honor, may I ask, will this be an in-person or another Zoom? Just so I'm well prepared because I was not.
Okay, we'll do it on Zoom.
Okay.
I mean, unless you can come in person if you wish, but if it's easier to do it by Zoom, we can do it that way.
Okay, that's fine. Thank you.
Okay, we'll confirm when we talk to you. Okay.
Okay.
Okay. Thank you. You're free to go today, and we'll see you in a couple weeks.
Stoner versus Reginald Stoner.
Okay. Thank you so much, Your Honor.
The defendant is not here.
Defendant is not here. Okay. Sounds like the last case I had.
Oh, okay.
Well, defendant's not here. We'll proceed with you, Ms. Huffman. Tell us what are the issues in dispute in this case?
Well, I mean, custody, parenting time, and support. There's going to be property and debt, I think. Pretty much all of the issues. I don't think child or spousal support is that issue. Currently, there's some cars of Mr. Stoner's that are on the property that my client's going to be getting citations from the city if he doesn't pick them up, and she's kept asking him to pick them up and he's not. So I'm not sure what's going to happen with that.
Okay. Okay, are you in need of discovery in this matter?
I think just a short one, probably December 1st would be fine.
Okay.
I would like Mr. Brundage and then Kelly if.
Okay.
Would Your Honor want me to file a motion and set that for a hearing for the car issue, or is that something?
Yep. No, we're gonna have to set it for a hearing.
Thank you. I think mediation then would be due in, is it December or January?
December.
December, okay.
And we will come back on January 13th for the settlement conference. 1:30 p.m. Parties are required to be present. Anything else, Ms. Huffman?
I don't believe so. Thank you.
Okay, you'll get this in probably in about a week and then we'll proceed from there.
Sounds good. Thanks. Have a good day.
Thank you. Yep, bye.
All right,
Bye.
thank you, defendant and Mr. Addy for the receiver.
Okay. Good afternoon to everyone.
Good afternoon, Your Honor.
Mr. Brody, I'll let you enlighten me. What's happening in the case and where are we at? The case is getting very old.
No, I agree, Your Honor, and in large part, I'll have to turn to counsel for a defendant and the receiver because I don't know what's going on, frankly. The receivership was established, which of course puts a stay with respect to this litigation in place, and I'm not sure what the status of that receivership is, but my understanding is unless and until that stay is lifted, we're just kind of here with our hands tied and can't do anything to move toward resolution.
Okay.
Go ahead.
Your Honor, Eric Addy on behalf of the receiver of defendant. I agree with everything Mr. Brody just said. We are still in a stay. The receivership is still pending. Unfortunately, our hands are also tied and we are also sitting here waiting because on October 12th of 2023, the Ingham County Circuit Court granted the receiver's motion to approve the sale of substantially all receivership property to a designee of plaintiff in that matter, which is Skyment's senior secured lender. The sale has been, the APA has been executed, but an interested party appealed the order approving the sale of receivership property, and that appeal is still pending. All briefing has been included, and we are simply waiting for the Court of Appeals to schedule a date for oral argument on that appeal. The sale of receivership property is, the biggest step in the receivership, the administration of the case. Once that sale closes, we will begin to be able to wrap up the receivership process. Has the Court of Appeals stayed anything on this matter or not? Yes, the enforcement of the sale order has been stayed. We did seek clarification with the trial court judge, who also confirmed that we may not move forward on closing on the sale until the appeal is resolved. Okay, well, enlighten me, what's that do for us in this particular matter? Well, we do anticipate that the Court of Appeals will schedule oral argument here shortly. Again, the underlying order that's been appealed has been was entered more than a year at this point. The general process here would be, the receiver may establish a claims process, and all unsecured claimants, like Mr. Brody's client, the plaintiff in this matter, would receive notice of that claims process in the event that it occurs. And to be candid, it does not appear that the receiver will move forward with the claims process, but again, that remains to be seen, and we'll have to assess that situation once the sale closes. Okay. Mr. Zalagi, what's your thoughts on this?
My thoughts mimic those of the receiver in this matter. Frankly, at this point in time, to continue to just simply kick the can down the road, I think just clogs the courts and is kind of a time crunch on this. So with that said, I don't know if there is a possibility of a dismissal with the right of the plaintiff in this matter to reopen the matter if, in fact, the receivership dissolves and, some kind of order where we're not sitting here and clogging up the courts and wasting Your Honor's time in doing so. So a dismissal with the ability for the plaintiff to reopen the case if, for some reason, the receivership doesn't go through is kind of the only thing that I could throw out there as a possible way of handling this matter without wasting everyone's time sitting here waiting for the Court of Appeals to reconcile itself.
Right. Mr. Brody, what are your thoughts on that? If we did an order dismissing it with your right to reopen it sometime in the future?
Yeah, and conceptually, that sounds okay, Your Honor, and I don't know the mechanics of all that. I would think it would be functionally equivalent to just enter an order, whether it's the court entering the order or a stipulated order that stays these proceedings unless and until the receivership proceedings are concluded, akin to a bankruptcy order, an automatic stay in a bankruptcy case, Your Honor, where the case doesn't get dismissed, just an automatic stay comes down and nothing happens with the case unless and until the insolvency proceeding is resolved. So I would think that would be an appropriate way to handle this.
Okay, what are all your other thoughts on that? I like the dismissal better, but I understand why you wouldn't want to dismiss it maybe.
Yep.
Yeah, the receivers will be open to either avenues.
And Your Honor, I'm happy to draft a stipulated order for Mr. Addy and counsel for the defendant to review that we can submit to the court forthwith, if that would be appropriate.
Okay, why don't you do that? The only thing I would say is probably, I don't want this to get left indefinitely, and so what I'm gonna do is I will schedule a follow-up status conference, even though we have your agreement to stay at. I'll follow that up in maybe 90 to 120 days, somewhere in that area, so we can see what's happening.
That sounds great, Your Honor.
Okay.
That works, Your Honor.
Okay.
Hopefully we'll have more clarity at that time.
Yeah. We will then get it reset about 90 to 120 days, and hopefully we get some resolution by the Court of Appeals and then the trial court up in Ingham County, and we can see where we're at then.
That sounds great. And Eric, I'll circulate a draft order to you guys.
Okay, thank you.
Thank you all.
Thank you, Your
Have a
Honor.
good day.
You too.
All right, thank you.
Good afternoon to everyone. Start with you, Mr. Hatch, because you represent the plaintiff. Tell me what's happening in the case.
Good afternoon, Your Honor. Dan Hatch on behalf of the Chapter 7 trustee for Plaintiff Miller Wholesale, Inc. Happy to report that the parties engaged in facilitative mediation on September 27th with Mr. Mac Wardrift and have settled all of the claims in this case, contingent upon the bankruptcy court's approval of that settlement agreements. We have passed that over to the U.S. trustee. He has raised some very minor revisions to the settlement agreement that I think we have the consensus on all the parties to make. So hopefully we can get those all made within the next couple of days amongst counsel, and then we will resubmit the settlement agreement to the bankruptcy court for approval.
Okay. Mr. Abood, is that your understanding as well?
That's my understanding.
Okay. And Mr. Cheltenham, is that your understanding as well?
That'll be Mr. Noble.
Oh, Mr. Noble?
Yes.
Mr. Noble is with the Abood Law Firm. I'm speaking on his behalf.
Oh, okay. Got it. Okay. Mr. Mataloni, is that your understanding?
It is.
Okay. Well, what we'll do is keep us posted then, and we will put it out and probably reset for about 60 days just to make sure that we have it on the calendar and doesn't get lost and ignored, so to speak. So we'll reset it, and hopefully in that, if we get something before that time, then that's fine. It'll take care of it, and we can get this matter resolved and dismissed.
Thank you, Your Honor. Just one other thing too for timing for the court. I'm told by general counsel for the Chapter 7 trustee, it'll probably be 21 days until the bankruptcy court makes a decision, hopefully to approve the settlement agreement. And then our settlement agreement contemplates us filing a dismissal with the court 14 days after the bankruptcy court's approval. So just to let you know when we could potentially get this off your deck, clear the decks.
Well, it sounds like if we reset it in 60, that should have it done in that time. If we do, we have the order, then there'd be no need for you to appear at that other status conference then.
Yep, I just want to let the court, a lot of times the court wants to know, when am I getting this off my docket, right, with the
Yes,
settlements?
exactly.
So we're not going to, it is a prolonged period for a payment of the settlement amount, but we're not going to keep the case open. We can dismiss it, and that's contemplated in the settlement agreement.
Okay. Thank you. Anything else from anyone?
That's it. Thank you.
Okay, thank you all. You're free to go. Have a good afternoon.
Thanks, Judge.
Thank you, you too.
Okay, thank you. Moving in, Spencer for the plaintiff and Attorney Castleberry for the defendant.
Okay. Good afternoon, gentlemen.
Good afternoon, Your Honor.
I'll go to you first, Mr. Spencer. Enlighten me. What's happening in the case?
Well, Your Honor, we've had Attorney Castleberry and myself have had some communications back and forth, emails and a couple telephone conversations. And unfortunately, at this point, we're not able to tell you that we have a settlement in this matter. We're a ways apart yet, Your Honor. So unless Attorney Castleberry feels differently, I would think that we probably need to go ahead and obtain a scheduling order from the court or proceed forward. We're still going to certainly work to facilitate a resolution, but we have not reached one yet, Your Honor.
Okay. Mr. Castleberry, is that your understanding as well?
It is, Your Honor.
Okay. I'll set this out for trial. How many days, Mr. Spencer, do you think it's going to take for us to resolve this?
Oh, I think we can get it done, I would think, in a day, Your Honor.
Mr. Castleberry, what's your thoughts?
I agree, Your Honor.
Okay. Okay. We'll set it for a one-day trial. I will tell you, it'll probably be January. I'm just noting, it might get in before that. I'm just saying that we've been scheduling a lot of things, so we have had things filled up through December, but it's possible we can get in, but we'll be in contact with both your offices, see when your schedules are available and when they can sync up with ours. Okay?
Very good. Thank you, Judge.
Okay, thank you both. You're free to go. Have a good day.
Thank you. Thank you.
All right, thank you. continue. I'm Attorney Yerk for the plaintiff. I do not have attorney, I forgot his name, for the defendant.
Okay, Mr. Yurt, looking at this matter, looks like nobody wanted to come to your party, so. tell
Well,
me what's happened.
the good news is that hopefully the party's over. Mark Husel from Dickinson is on the other side. He represents the owner. It's a lien foreclosure case. Mark was able to broker a deal between myself and the contractor. We have a settlement agreement we agreed to. I signed it. I'm waiting for the contractor to sign it. Mark's holding it in until payment is funded. So we're just about at the finish line of resolving it.
Okay. Well, we won't take up any more of your time. We'll hope to get that in here shortly. And do you have an idea when we should receive that?
I was hoping we receive it last week. I apologize. This wasn't even on my calendar. It's my fault. I apologize. I'm usually not tardy. So my hope is this week. I'm just waiting on payment from the contractor.
Okay. Well, keep us posted. When you get all the paperwork back, send a call our office, just alert us so we can be looking for that and make sure we get it entered.
Yes, sir. I appreciate your patience. Thanks, Judge.
Okay. Thank you. You have a good day.
You too.
All right, thank you very much. Let's move on for the plaintiff and Attorney Hansma for defendant Schaefer Ready Mix, and I do not have Mr. Pfeiffer.
Okay. Ms. Nichols, let us know what's happening in your case.
Your Honor, I'm happy to report that we have reached a settlement. We agreed on the primary terms last week. My office has circulated a proposed settlement agreement and release of all claims that the defendants are currently reviewing. I would expect that we'll be able to wrap this up within the next couple of days at the latest. And we appear to be in a very good spot, Your Honor.
Good to hear. Ms. Kleinman, is that your understanding as well?
It's Ms. Hansman. Yes, that is my understanding.
Okay.
Sorry, Mr. Kleiman's the other gentleman from my office.
Yeah, we still have his name on the file, so that's why.
Well, he is still on it for some things, but he's not here today.
Okay.
So yeah, I agree with everything that Ms. Nichols just said. We did receive the draft settlement agreement that she drafted. We're in the process of circulating it. We have some non-parties that are going to be also added to it, so we have to get it over to their attorney for review. And but we agree it probably should be a couple days, and we should be able to get this wrapped up.
Okay. Great. Well, we'll look forward to that. Get the paperwork in, and we can get the matter resolved.
Sounds great. Thank you, Your Honor.
Okay. Thank you both. You have a good day.
Thank you. You too.
Bye.